SJC-12496, Commonwealth v. Jameson, Phuon.
Mr. Reardon, good morning.
Good morning, Your Honors. Attorney Theodore Reardon for the defendant, Jameson Phuon. With me today is Attorney Deborah Reardon. Mr. Phuon's first-degree murder conviction must be reversed because the jury was instructed that they must convict for the highest degree of murder proven by the Commonwealth. The jury returned two verdicts in this case, that the defendant was guilty of murder 1 and guilty of murder 2. By convicting him of murder 2, there is an ambiguity as to whether murder 2 was the highest degree proven by the Commonwealth. The following facts and circumstances support that there is an ambiguity in the verdict. Number 1, the jury was not instructed to consider murder 2 only if the Commonwealth had not proven murder 1. Number 2, the prosecutor stated that the jury had returned, quote, both verdicts and requested further inquiry to, quote, make sure everyone was on agreement on the first. The fact that the prosecutor made this request supports that she thought there was an ambiguity in the verdict. And likewise, the prosecutor also mentioned that she had past experiences that juries did not understand that it's either murder 1 or murder 2, but you can't convict for both. The most helpful case that I've been able to find to support Mr. Phuon's position is the Dunn case, where the jury was instructed, Mr. Dunn was charged with armed assault with intent to murder. There was no lesser offense instruction, but the verdict slip stated that the offense was the lesser offense of assault with intent to murder. The court held that whereas there was no instruction on the lesser offense, there was no doubt that the jury intended to convict for the charged offense. But the court noted that if there was any reasonable doubt about whether or not the jury intended to convict for the lesser, the court would have given the defendant the benefit of that doubt. And in this case, that's exactly what we have. The jury was instructed on the lesser offense of murder 2. The jury did convict for murder 2, and thus there is an ambiguity as to whether or not murder 2 is the highest offense charged. For all these reasons, Mr. Phuon contends that his murder 1 conviction must be reversed. If the court has any questions, I'd be glad to entertain them.
Okay. Justice Frank, you wish to go first or last?
I think I'd like to go last, thank you.
Okay. Then, Justice Graziano, you're up.
Thank you. Good morning, Mr. Reardon.
Good morning.
So, the defense counsel did not object to the procedure used by the judge, right?
Well, what happened was he initially asked for the jury to be polled as to the murder conviction. And when the clerk started to do so, the clerk became aware that murder 2 and murder 1 were both checked off on the verdict slip. That's when a sidebar was held, and the defense counsel consulted with the defendant and decided not to pursue further polling of the jury. But at a later point, the prosecutor stated that she wanted to make sure that there was further inquiry to make sure that everyone was in agreement on the first. So even though the defense waived the further polling, the Commonwealth still wanted further inquiry to make sure that everyone was in agreement on the first degree.
And tell me what you think the judge should have done.
I think the judge should have made further inquiry as the prosecutor had requested.
Sent them back to the jury room and said, you can't have two verdicts. The Commonwealth the verdict is whatever is proven by the Commonwealth the highest beyond a reasonable doubt. Please clarify.
Yes, and actually the suggestion made by the prosecutor was that in past instances where this had happened, the jury had been sent back with a clean verdict slip and said, choose one or the other, but not both. So a redo on the verdict slips would have been appropriate. And
in this case, the judge basically did not. The judge wasn't not kind to say didn't do anything, but the judge basically said, well, one's a lesser included, so it's a murder 1, correct?
Correct.
That's essentially what she did.
Yes.
Okay. Thank you, Mr. Reed.
Thank you.
Justice Lowy.
Morning, Mr. Reed.
Good morning.
So the waiver issue is not the issue I really want to address because we are looking at this under substantial likelihood. But one of the issues here is that the verdict slips don't control. What controls is what happens in open court. Do you agree with that?
Yes.
And am I correct that when the foreperson was asked about first-degree murder, that the foreperson actually indicated what theory or theories that they were finding him guilty of first-degree murder, and that in fact they didn't find beyond reasonable doubt on one of them?
Yes, they did state the two theories that they found him guilty on. I don't think they explicitly said that they did not find him guilty on the third theory.
Okay. My memory may be wrong about that. Okay, thank you.
You're welcome.
Justice Budd.
Hi, good morning.
Good morning.
You said that there were, maybe I misunderstood, you said that there were 3 murder convictions?
No, I think the last question pertained to the 3 theories of murder.
Oh, okay. No, when you gave your presentation, I have noted here 3 murder convictions. I must have misunderstood.
Oh, I'm sorry.
No problem. Okay, so I'm just trying to understand your theory that why does finding the defendant guilty of both first-degree murder and second-degree murder suggest that the highest offense proven is second-degree murder?
Well, when the jury was instructed, you are to find the defendant guilty for the highest degree proven by the Commonwealth, and the jury checks off murder 2. There's a suggestion that murder 2 was the highest degree proven by the Commonwealth. And in some cases, juries are charged that, especially when going over the verdict slip, that you don't need to get to murder 2 if the Commonwealth has proven murder 1. Just skip over the rest of the verdict slip. But that wasn't given in this case. So the omission of that instruction about you don't need to get to murder 2 if murder 1 was proven, coupled with the fact that they were instructed that you must convict for the highest degree proven by the Commonwealth, lends to an ambiguity as to whether or not murder 2 was the highest degree proven.
Yeah, I'm really having trouble with that because I'm looking at the verdict slip and it clearly has marked murder first degree, guilty of offense as charged. And I see further down it also has marked guilty of lesser included offense of murder second degree. But that doesn't negate the fact that it says above guilty of murder first degree.
Well, not necessarily negated, but it creates an ambiguity as to whether or not which was the highest offense proven. And I think the prosecutor herself felt that there was an ambiguity, and she wanted further inquiry because she believed that there was a question of what was the highest degree proven.
She probably wanted clarification so that something like this wouldn't happen, huh? Well, at any rate, just turning very briefly to the second issue, the fact that there were convictions of both possession of ammunition and convictions for possession of a loaded firearm. What should have happened here?
What should have happened was after the jury returned its verdict, the counts for 24 and 25 for possession of the ammunition should have been dismissed as lesser included of 22 and 23. They should have just been dismissed.
Okay, and that's what you're asking for?
Yes, please.
Okay. Thanks. I have no further questions.
Thank you.
This is Chief Justice Gantz. The verdict slip, which I'm looking at, has some printed names on the side. Were those printed by the clerk, or were those printed by the foreperson of the jury as to the names of the individuals?
They were printed by the foreperson, I believe.
Okay, and I've never seen a verdict which says by what weapon. So this was also a special verdict? They were supposed to... What was the felony murder theory?
The felony murder, I believe, was the home invasion.
Oh, I see. Okay, so it was a home invasion, and then were they asked to? I mean, I have to go back to, I guess, the judge's instructions. Did she ask to identify who the victims were of the home invasion? Did these names, and then was asked specifically to identify by what weapon? Was that because only a firearm trying to think, would it matter as to whether it was a life felony?
So each one of these individuals, they were shot. And so the other indictments all pertain to offenses as to these individuals.
I see. Okay. I mean, looking at it, I mean, I think my own guess is that what the jury did was they said we find him guilty of first degree as to two theories, and we don't find him guilty as to the theory of extreme atrocity or cruelty, and as to that theory, we find him guilty of second degree. But of course, we don't positively know that. Taking the point, I think I wrote done, so I'm not departing from it, but where a jury finds the person guilty on a theory of premeditation, is there any uncertainty that the jury intended, at least as to that theory, that it be first degree?
Yeah, I don't think. I think that there is an ambiguity as to whether or not murder 2 was the highest degree proven by the Commonwealth under any version, under any theory. And by the fact that they checked off that murder 2 was the highest degree, they were instructed to find the defendant guilty of the highest degree proven, and they checked off murder 2. So it would be opposition that murder 2 was the highest, at least as to some jurors, murder 2 was the highest degree proven by the Commonwealth.
Okay. I have no further questions. Justice Lang?
Yeah, I'd just like to explore a little bit the whole notion of having the ambiguity created by a document that doesn't matter. The verdict slip doesn't matter, does it? It's said in open court, right?
It is, but that lends to the next problem that the jury, the court received a partial amount of the jury's verdict. It did, under the Lawrence versus Stearns case, it's supposed to receive the complete and valid verdict. And
well, tell me what was said. Could you tell me what was said? I am looking for it. I can't find what was said by the when the clerk read the jury verdict in open court, and then asked the jury foreman to affirm that this was a verdict of the entire court. I'm not sorry, the entire jury. What were the words used? Could you explore that with me, please?
Sure. And this is on pages 16 and 17 of my brief.
Okay.
I can read the transcript if you'd like.
Please.
It says, okay, the clerk says, Madam Foreperson, has your jury agreed upon its verdict? Foreperson says, yes, we have. Clerk says, pass the verdict forward, please. The court says, all right, they are in order and may be recorded. Clerk, Madam Foreperson, on indictment number 2011-137, number 1, charging the defendant Jameson Phuon with the offense of murder. What say you? Is the defendant guilty or not guilty? Foreperson, guilty. Clerk, guilty of what? Foreperson, guilty of offense as charged. Theory of premeditation, guilty. Theory of extreme atrocity, not guilty. Theory of felony murder, person other than Karine, I'm not sure how to say the name, Ower, guilty. The clerk, members of the jury, you will hearken to the verdict as it is recorded by the court. Jurors, on their oath, find the defendant guilty of murder in the first degree as to the theory of premeditation and as to the theory of felony murder. So say you, Madame Foreperson. Foreperson, yes. The clerk, so say you all, members of the jury? The jurors, yes.
Okay, and then he inquired of the jury as to the verdict as to the remaining indictments, right?
Correct.
And did he inquire as to the indictment as to, was there an indictment for murder 2?
No.
So the jury expressed its verdict on the last indictment, and he requested that the jury be polled as to its verdict on the first indictment, and he was doing so, and noticed the verdict slip. I'm sorry, the clerk, she asked for a moment, at which point she told the judge, and the judge expressed her view the verdicts were not inconsistent, and so on and so forth. And you're saying that the document that did not matter, that was never read in open court, is the one that is somehow going to tell us what to do? I don't understand that. I don't understand when you've got something orally said in court and never contradicted by anybody else. Why it is that would not be the governing thing under our cases irrespective. I mean, suppose there was no verdict slip. Suppose the verdict slip was destroyed inadvertently, or deliberately. Would that have changed the verdict in this case?
Well, I don't think the verdict slip is completely irrelevant. There are several cases I cited in my brief that discuss how it's a good indication of what the jury intended in reaching its conclusion. And while the portion I just read is what happened in court, I'm citing to the Lawrence versus Stearns case from 1832, where the court said that the trial judge must receive the complete and valid verdict. And it's our position that by not inquiring as to murder 2, the court did not receive the complete and valid verdict.
Why not?
Well, because we have an indication.
I understand the verdict slip, but I mean, if you were listening to what was being said in open court, what was the clerk should have done that she didn't do? Was there some indictment for murder 2?
Well, there was an instruction on murder 2, and I think the clerk should have inquired, given that there was an indication on the slip, what did you find as to murder 2?
Mm-hmm. Okay, thanks.
Thank you.
I don't have anything else.
Any further questions of the justices? Hearing none, Mr. Reardon, thank you. And Mr. Ferreter, you may commence.
Thank you, Your Honor.
Thank you, Your Honors. Timothy Ferreter, Assistant District Attorney for the Commonwealth from Middlesex. I first want to start with the Dunn case and the language that was used in that case. If there's any reasonable possibility that the jury intended the lesser verdict, we would give the defendant the benefit of that lesser conviction. I think it's important to point out that the Dunn case is the exception to the normal rule. In that case, both the verdict slip and the clerk, when he inquired of the jury, used the language assault to murder instead of armed assault with intent to murder. The trial judge, chalking it up to a scrivener's error, recorded the verdict as armed assault to murder, and this court, finding that there was no possibility that the jury intended the lesser included offense, allowed the exception to rule in that case and allowed the armed assault with intent to murder conviction to stand. Here the Commonwealth is asking this court to apply the normal rule, not the exception. Normal rule being nearly 200 years old from Lawrence v. Stearns, where the only verdict which can be received and regarded as a complete and valid verdict of a jury, upon which judgment can be rendered as an open and public verdict affirmed in open court. Meanwhile, the verdict slip has been held is of no binding legal significance. In this case, the jury, who was properly instructed on the elements of murder, instructed that they must be unanimous as to each theory of murder, and on their duty to return a verdict on the most serious offense proven by the Commonwealth, returned the verdict of first-degree murder in open court, which was affirmed by the entire panel. And I think there are other cases that stand in stark contrast to this, particularly the Powers case from the appeals court, where the verdict slip indicated the exact opposite of what was announced in open court, but the open court verdict is what stood. And if there are any questions, I'd be happy to take them.
Okay, Justice Galciano.
No questions, thank you.
Justice Louis.
Hello? Hello?
Justice
Yes?
Louis?
Yes. No questions. Thank you.
Justice Budd.
I'm all set. Thank you.
The better course would have been to go back to the jury, wouldn't it?
The judge suggested that polling continue, and it was the defense attorney who, after consulting with the client, explicitly waived polling. So I think it probably would have certainly eliminated this issue, but the defendant explicitly waived polling, which is why we're here under 33E review. I think most likely tried to preserve this error to have something in a really case with overwhelming evidence, to have something to present on appeal.
Right. And therefore, isn't it the better course for the judge to have done what I think what the prosecutor suggested was proposed by at least another, I believe, quite experienced prosecutor, which is to instruct the jury and make sure that you eliminate even this issue?
Yeah, so I agree, that probably would have been better. The judge actually, when she noticed the error everyone to sidebar suggested that polling continue in order to eliminate this issue. As a defense attorney who explicitly waived polling, the prosecutor's comment, which is being referred to, unfortunately wasn't made until after the jury was already discharged. I think by then it was too late, but it would have been the better course, but it didn't happen, so we are where we are, but there's no substantial likelihood of a miscarriage of justice.
I have no further questions. Justice Link?
I have nothing, thank you.
Okay, thank you. I will conclude then this argument. Thank you both.
Thank you.
Take care.
Now exiting.